Indian news ma wakwa assign the ba wan kasa fidie so bio. Na maka trust before anything else na just a share na ebiem so kwa na wo subscribe to your channel no. What's the political news there? Never governance. We catch you sa pan put to forma yet. Na pan to forma yet there. Ane na nsɛm foforɔ bi nso asan asi. Benim sɛ wode yɛ nsɛm a de bɛn nyinaa no yɛ na yɛ wɔ tɛ na yɛ wɔhɔ na yɛ wɔ fɛ nso so. Nti no nsɛm foforɔ bi asi a Nindie news yɛn nso so pan yɛ tɔɔfo mi baabi yɛ ti nyinaa akyi no yɛn nsa atumi aka bi na yɛaso nso atumi ate saa nsɛm bi. Yɛntie nsɛm mmra sisi a na mpanimfoɔ mpo sɛ kakum no yɛkyɛ no kɔkɔɔ anum. Deɛ ba before that no subscribe to your channel no. Ɔmsa bɛka all other news a ɛfa politics wɔn de deɛ wɔpɛ sɛ wɔteɛ no ɛho. Etie ba ebe ba bia susu anso pɛ so de bɔde ho fa na de asie bia no nso fa comment nso to aseɛ na yɛnkenkan mfama wo de ready na ɛmɛkɔ yɛntie nsɛm mmra sisi a wotie no fa comment to aseɛ ba yɛmfa nkyɛmu no nso nto aso yɛntie mmra.
Of course, your comments are welcome. We are live on X Spaces, on Facebook, on YouTube, and of course on myjoyonline.com. Your comments will be shared here on this program. This is a pulse. My name is Elton Brobe. Now, this afternoon, we are starting from the stables of the Supreme Court of Ghana, and the court has, by a 2-3 decision, dismissed an injunction application by the Member of Parliament for Old Tafo, Vincent Asafua, challenging President Mohammed's decision to suspend Chief Justice Gertrude Tokono by a 3-2 decision, with Henrietta Mensah Bonsu and Ernest Gau dissenting. His Lordship Justice Bafuboni, Justice Amadou Tanko, and Justice Yoni Kolende voted to dismiss the application. Now, let's take a look at how the voting went. And of course, so this is how it went down to the Supreme Court dismisses injunction challenging the Chief Justice's suspension. So the 5 members that sat on this panel, 3 voted to dismiss the application. And my colleague Latif Idrisu is our legal affairs correspondent. He's in the studio and is going to help us walk through the graphics as we have it. So Latif, if we can help understand them of what we have on our screens this afternoon.
Yes, so just to deal with the graphics that we have. So we have 5 members sitting on the panel. And let's state for the record that this is a different panel compared to the panel that started this particular case. And we'll get into that, I'm sure, going forward. So we have Justice Geu and then Justice Henrietta Mensah Bonsu, both of them dissenting. And then we have Amadou Sule, Justice Amadou Sule. We have Justice Bafuboni, that is the acting Chief Justice, and then Justice Yoni Kolendi. All 3 of these voting to dismiss the said application. And you have it on the screens right now. We have the acting Chief Justice, Justice Bafuboni. We have Justice Amadou Tanko. We also have Justice Yoni Kolendi. So these 3 you find on your screens voted to dismiss the application brought forth by the Member of Parliament for Old Tafo. And then you have 2 other judges who voted to sort of dissent on the application. So you have Justice Henrietta Mensah Bonsu and Justice Ernest Geu. These were the dissenting voices.
They voted to say that the application
must hold.
Must hold.
Yes.
And that according to them, the suspension was not right.
It's not right. And so the warrant that was issued by the president to suspend the Chief Justice, according to these 2, Justice Henrietta Mensah Bonsu and Justice Ernest Geu, that must be respected, and the president's order has to be suspended.
All right. So initially, this was not a panel initially.
Exactly.
This panel that took the decision today
it's a reconstituted,
went through some kind of modification.
Exactly.
So first, let's establish the initial panel that was constituted by the suspended Chief Justice.
So those who are absent on this particular panel are Justice Wamang and then Justice Asiedu. And now we all know that these 2 justices have been appointed by President Mahama to sit on the committee that is investigating the allegations as captured in the petitions. So they couldn't have been present on this same panel, hearing the matter, and then be on the same committee that is going to investigate the allegations that have been made. clearly that would occasion some level of conflict, if you like. And so that was the argument that Justice Amadou Tanko made to the learned lawyer, the former Attorney General, Godfrey Adame, when he insisted that the acting Chief Justice
himself
ought not to be on the panel.
On this panel.
Because in the minds of the former Attorney General, Justice Bafo Boni stands to be the ultimate beneficiary of the outcome of the procedure that has been triggered by the President.
That is in event that Getty Tokono is removed as Chief Justice of the Republic.
Exactly.
Because he is already acting.
Exactly. So, and then for someone who stands to benefit, you cannot set up a panel.
You take a decision that affects the person for whom you are acting in her capacity.
Exactly. Because you benefit at the end of the day. Then the argument by the panel was that, no, they quoted Article 1446 of the Constitution and says that once he is acting as a Chief Justice, that is an office that he, as a person, is occupying.
Right.
He is not barred from undertaking his role, his duties as an acting Chief Justice. And so the argument by the former Attorney General doesn't hold. In fact, this particular section went on for a very long time. It was back and forth with the former Attorney General quoting some provisions in the Constitution, quoting some papers that have been published, quoting the Ghana Law Report from the 80s, and all of trying to make a case that indeed Bafo Boni ought not to sit on the panel.
And the decision after all the back and forth, after all the arguments was that?
So there was a unanimous decision
that all of them voted against the application by the former Attorney General.
That Bafo Boni ought not to be on that particular.
And so clearly this was a unanimous decision.
Unanimous. Then there was another objection by the former Attorney General, which had to do with the constitution of the panel itself. That, I think that's what we have just dealt with.
Right.
So it had to do with Bafo Boni also. I think we've dealt with that
right,
one.
Exactly.
So those were the two objections that were dealt with by the panel. They dismissed all two. And then...
And then after this, they moved to the matter of the injunction.
Of the injunction, exactly. So on the matter of the injunction, that was when we had the decision that the President is performing a constitutional duty. And per the Constitution, you cannot enjoin someone from performing a constitutional duty. In fact, there was the issue of timeline that, the case of the former Attorney General was that failure by President Mahama to notify the suspended Chief Justice that I have received some petitions asking for your removal. Failure by President Mahama to do that constitutes a constitutional violation of the rights of the suspended Chief Justice. Now, it was the position of a panel member that the former Attorney General should point the panel to the section of Article 146 that stipulates the timeline within which the President ought to notify the Chief Justice that I have received a petition asking for your removal. In fact, that one is not available. It's not captured anywhere in the Constitution. And so the Attorney General could not point to that particular provision in the Constitution that stipulates timeline during which the President is expected or supposed to notify the Chief Justice once he receives a petition asking for the removal of the Chief Justice. It doesn't exist. And so, again, back and forth, and that was when the decision was made that by 3-2 majority decision, that application has been dismissed by the Supreme Court.
Meaning 3-2, it was not a unanimous decision.
It wasn't a unanimous decision.
3-2 means, in the minds of the two, they had a case.
Exactly. So in the minds of Geu and Henrietta Mensah Bonsu, the argument and the position of the Old Trafford MP, the submission by his lawyer, the former Attorney General, hold some substance. And so they went that direction and they voted that the warrant issued by the president must be withdrawn and the Chief Justice reinstated to her substantive position as a Chief Justice.
And then the other three, led by the acting Chief Justice, is of the firm belief that there is no case.
There is no case, and so they dismissed all the application filed by the members.
All right, let's listen to the former Attorney General Godfrey Dame after the court, after the matters in the Supreme Court. He spoke to the media. Let's listen to him.
But just your initial reaction to this particular ruling.
Well, I think that I find it quite intriguing to start with that the acting Chief Justice himself will preside over the proceedings, and as I indicated, I find it very incongruous because indeed, if at all there's any beneficiary from all of these developments, then the acting Chief Justice is a direct beneficiary of this. Of course, it's the constitutional as Minister Senior, but clearly we cannot lose sight of the fact that whatever has happened, the benefit of it accrues to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there has been a dispute as to the status of the Chief Justice in this country, start from 1980 before an Attorney General, start from 1983, 94, Aban, and we go to 2005, there about J2 and all. The Chief Justice in question panel the court, but never sat on the matter. I mean, so it cannot be right for the acting Chief Justice to sit on the matter. But that's it. We see the 3-2 ruling, very narrow decision. We wait for the reasons. When the reasons come, we definitely advise ourselves. The narrowness of the decision itself indicates clearly that the application, no doubt, had merit and we know what to do. All right?
Your main argument, your final was the fact that the president's failure to notify the Chief Justice from the outset constitutes an egregious constitutional violation. But one of the panel members pressed you. He wanted you to point the panel to the clause in Article 146 that clearly stipulates the timeline.
The reasons for the decision have not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie determination made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it authenticated on the J2 matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his requirement before triggering the process. And that is what is in dispute before the court. And my contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process.
Right, so that's the former Attorney General Godfrey Dame, at some point flagged by the Akwasuman, who was the legal counsel to President Akufo-Addo during the 8-year administration of the president. Now, there was a response from the Deputy Attorney General who represented the state in this case.
Yeah, his point is that the judgment of the court is a position they have held over the period, that indeed there's been no breach by the president has not violated any constitutional provision as, suggested by the learned former Attorney General Godfrey Dame.
So when we see the reasoning, of course, then we will know whether the court dissented, the justice dissented, or dissented. There was any basis for it. There are so many reasons why the court dissented, but you were in court and you realized that the question was consistently breached. What exactly are you alleging? What is the right that you are alleging? And to pile up a series of newspaper publications claiming that because newspapers are published that the president is attacking the judiciary, that is enough for the president to stop the process. So the process is unconstitutional because newspapers are published. That cannot be a very strong legal basis. And when you saw the attachments of newspaper publications, many of them, I don't think that publication is a legal right or determines the legal right for anyone.
Okay, so for the decision that has been taken today, what does it mean to the process that is currently before the committee that is supposed to be?
Well, it means the process will go on. The process will go on. The committee would sit, would hear the inquiry into the matter. And of course, I have always maintained that the finding of prima facie case is not automatic that the Chief Justice or the person who is being who is the subject matter of the petition has been removed. It is not at all. So it may come out that the Chief Justice, the petition has not been of merit, and the Chief Justice will be restored to a position. I am always surprised that people have concluded that the fact that prima facie case is found then means that the Chief Justice automatically remove from office. You see, that is what actually motivates this petition, this motion that have been filed. I think the underlying understanding, which I consider a misunderstanding, is that the plaintiff believe that when a prima facie case is established, then it's a gone issue. But it is not.
All right, so that's Justice Rimsai. He is a Deputy Attorney General for the Republic, and he was in court today. Of course.